All right, welcome to the webinar on the new veterans rules that are going to affect the veterans benefit known as aid and attendance. We'll be touching on the new net worth limitation, the look-back period for gifts, and those transfer penalties. Now, we have done a webinar in the past about aid and attendance, but this webinar is intended as an introduction to the new rules for applicants. My name is Matt Parker. I'm an attorney with the firm, Marshall, Parker & Weber, and I'll be spending the next 30 minutes going over those rule changes. Now, keep in mind, there are some new changes that we're not going to review. If you ever get a hold of those materials they have online about these VA rule changes, there's quite a few of them, and some of them are, quite frankly, too detailed to try and explain within the 30 minutes that we have. So I'm going to cover those that typically come up in the average application for aid and attendance benefits that affect our elderly population. All right. So before we begin talking about, let's see if we can get our slide presentation back to. All right. So before we begin talking about the new rules, let's take some time to discuss what is the aid and attendance benefit. It's a pension benefit. So it's a monthly amount of money that's paid to some of our veterans. It is one of those benefits for veterans with low income, and it's primarily intended to pay for care either at home or in assisted living or personal care home. Could be paid to a nursing home if somebody was privately paying as well. Now, the aid and attendance is the highest level of improved pension available to our veterans. Now, in order to qualify a veteran or even a widow of a veteran, they need to document the need for what they call the regular aid and attendance of another person. So typically, there's going to be a caregiver involved. Now, there are several ways to go about establishing this need. Typically, what the veteran has done is require the aid of another person to perform certain activities of daily living. Those could be bathing, feeding, dressing, and toileting. In other cases, the veteran is simply bedridden because of a disability. They could be a patient in a nursing home due to a mental or physical incapacity. Typically, we see dementia or Alzheimer patients fitting this category. And lastly, some veterans are legally blind and entitled to this benefit as well. Okay. So let's go over some general eligibility requirements for the pension benefits. The veteran must have served at least 1 day during a wartime period. Now, the actual dates that meet this wartime period are found on the Veterans Affairs website. They include currently the Second World War, the Korean conflict, and those that fought during the Vietnam era and the Gulf War, which is currently continuing to this day. Now, the veteran must have been discharged from the military other than dishonorably and served at least 90 days, and 1 day has to be during one of these active wartime periods. There's no requirement that the veteran was on the battlefield. He or she could have been stateside doing their service or in another theater. The veteran will need his or her discharge papers. It's called the DD-214. It sets forth your dates of service and the type of your discharge. Now, as I mentioned, the applicant will have to meet the medical criteria determined by a treating physician to determine if you need the pension benefit known as aid and attendance. We'll talk in a minute about the clarification in the rules with regards to what types of needs will be covered. Not all individuals, for example, in an assisted living facility are going to get aid and attendance. You have to meet the medical criteria in order to get assistance from the VA. In fact, with the new rules, there's a rather increased focus on whether an individual really needs the assistance with those activities of daily living. Now, here's the first of the several tests that have to be met before you receive aid and attendance. This is the income test. Now, generally speaking, the veteran's income must be less than an income limit known as the maximum annual pension rate. To qualify for the pension benefits, a veteran's income must be less than that income limit for the particular veteran. The income limit varies from veteran to veteran. It will depend on their medical status and whether or not they have dependents. All of the applicant's household income is counted unless it's specifically excluded. One of the big changes to the new rules is how one is entitled to reduce their income through what are called unreimbursed medical expenses. Now, these are some of the examples of the excluded income. So we have welfare, income tax refunds, IRA interest, loans, and reverse mortgages. Money a veteran receives from any of these sources are not counted in the application. Now, even with the income exclusions, most veterans have countable income that's still too high to qualify for a VA pension. So a vet whose income is above the applicable income limit may still be able to qualify for this pension by taking income deductions. So countable income can be reduced by what they call unreimbursed medical expenses. They include a medical expense, for example, has to be paid privately by the veteran or the spouse, an out-of-pocket expense. They could include medical insurance premiums, such as the Medicare insurance premium, as well as the supplemental insurance costs. Fees for in-home care, this is a big one. So if you have caregiver expenses, out-of-pocket care for a caregiver, that's a deduction. Fees for the assisted living or personal care or even nursing home care, those are all deductions that will reduce your income level. So in many cases, you have a veteran who has a few $1,000s worth of income, but they're spending $4,000 or $5,000 for their assisted living care, and therefore they qualify from this income test standpoint. Now, some of the new rules do restrict and clarify what can be used as an unreimbursed medical expense. They go on to define the activities of daily living as basic self-care activities that would consist of bathing or showering, dressing, eating, toileting, and transferring. Typical activities of daily living. You need assistance with at least 2 or more of these activities to qualify for this type of care. Thus, not all the charges in those assisted living facilities or personal care homes would necessarily constitute an unreimbursed medical expense. You can understand that some people who are in personal care homes are very independent, and they don't need assistance with those activities. In fact, personal care homes have different levels of care. We were talking about this morning. You have different packages that you can buy, and the increased amounts of money you pay entitle you to more care in these facilities. So those are veterans who might need additional care for those activities of daily living would have to establish that before qualifying for one of these pensions. Now, the new rules also clarify that instrumental activities of daily living are not considered unreimbursed medical expenses. So in many cases, caregivers or assisted living facilities are helping with independent living activities. They could include assistance with shopping or food preparation, housekeeping, laundering, managing your money, handling medications, transportation costs. All of those are instrumental activities of daily living, not going to be covered by the aid and attendance benefit. Now, for those of you in the home care setting, there are new restrictions on the reimbursement rates for home-based services. That is the hourly rate that you can get reimbursed under this program. The VA is clarifying its policy with respect to in-home attendance and limit the hourly in-home care rate that the VA would consider deductible. So each county is going to have a number, and they're saying this is what you can reasonably charge under the circumstances. What they're trying to do is cut down on fraudulent or excessive in-home care charges where they might be charging double the industry rate and trying to get reimbursed for that. So you're going to have to use an independent industry source to come up with the rate that's allowable, but your local VA rep will be able to direct you to what their number is at the moment. Okay, we're going to go on now to the net worth calculation. This is one of the 2 biggest changes to the rules that came into place last October, almost a year into these new rules. And this includes a change to the assets that are counted for purposes of determining if you're eligible for this aid and attendance benefit. When determining who is eligible for the benefit, the VA takes into account the assets owned by the veteran and the veteran's spouse. They're going to deny the application for benefits if the veteran has in excess of this countable asset limit. Now, in the past, you may recall that this figure really wasn't set forth in any rule or regulation. Generally, it was regarded as $80,000, and how they came up with that was a bit of a mystery. But now we have a new rule that has a bright line test for countable assets, now known as the net worth of the applicant. The figure is now the same as what they call the standard maximum community allowance that's used in the Medicaid applications for long-term care. Now, that figure changes periodically, but right now, as you can see, it's $126,420. Okay? And to arrive at this figure, The net worth includes not only the countable assets of the applicant, such as their bank accounts, CDs, your investments, your annuities, retirement accounts, cash value of life insurance. But these new rules now also count an applicant's annual income. That's right. 1 year's worth of annual income of the veteran is going to be counted and added to the total of other resources. So even though your money's in the bank and so forth might be under 126,420, when you add the income to the total, well, it might actually exceed this figure. Okay, so you've got to keep in mind the VA has a very different system than the Medicaid rules, where they don't count the annual income as a resource. Okay, we're going to move on. You just ask the basic question. Well, listen, you got this bright line test for net worth. How do you reduce your assets and become eligible? So the most logical way is to have a very large amount of unreimbursed medical expenses. That's the way most veterans are going to become eligible. They have this assisted living cost that's $4,000 or $5,000 a month. And when I say assisted living, I also mean personal care home. It could be in a nursing home, and then you have like a $10,000 a month deduction every month. So those people are more than likely going to be eligible. If they don't have a lot of other savings, they'll be able to reduce, for example, their annual net income by having these large expenditures for assisted living. Even home care expenses could greatly reduce that figure. Spending down the excess resources is also permitted. I met with a client yesterday, and she was going to set up a burial account for her dad, and she was going to perhaps buy a new car for him. And so those are sort of basic living expenses that you can legitimately spend your money down on. The VA doesn't want you spending monies on things that are not essentially for your living expenses. They also allow for education. I suppose in some cases for younger veterans that would be allowable. Vocational rehab also permitted as well. So the net worth or countable assets are no longer going to take into account life expectancy. Some people in the past thought that the older you are, the less money you'll be able to keep, or the younger you are, the larger the number. That's no longer a factor here. That resulted in very inconsistent results for the applicants. So these rules are pretty consistent across the board. All right, I do want to point out that we have a new rule for the residents. Now, there are exempt assets for this aid and attendance program, and they've always included the principal residence, the household goods, that is the stuff you have in your house. The motor vehicles used to transport the veteran as well has been exempt. So you have these assets that were sort of set aside and said, listen, we're not going to count these. However, there's a rather troubling restriction on the exemption of the residents that could prevent some veterans from obtaining the benefit. So what the new rule does is they provide that the Veterans Administration will exempt the primary residence, but only if the residence and the land or the acreage around the house does not exceed 2 acres. The 2-acre limitation concerns some of our practitioners and veterans, particularly those who are in rural areas where they're relatively poor veterans, but they have a home with, let's say, 5 or 10 acres. There are provisions in the rules for the applicant to claim that the additional acreage just isn't marketable. You can't carve off 2 acres and sell it to somebody else, therefore it doesn't have any value. But it's unclear as how it's going to be applied from case to case. So the 2 acres situation would require you to essentially value the acreage above the 2 and add that to your net worth limitation. So you could have 100 acres perhaps that are worth something that are preventing you from qualifying for the aid and attendance program. Now, some other rules about the residence. If it's sold and the proceeds from the sale are used to purchase another home within 1 year, those sale proceeds won't be countable. Now, if the veteran happens to move into a nursing home or assisted living or similar facility, you're not going to count the home simply because they had to relocate because of health needs. So that's a good benefit for the veterans who have to relocate. All right. I've got to go after the new gifting rules that are out there. The VA now has a look-back period. In the past, the VA didn't impose a penalty for giving away assets that reduced the net worth. So an applicant could transfer assets the day before applying for benefits and could receive eligibility so long as the assets were then below the countable limit. Now, for these new applications after October 18th of last year, the VA is entitled to look back 3 years to determine if any transfers for less than market value were made. The VA can then impose what they call a penalty or a period of ineligibility for aid and attendance benefits. Now, keep in mind the timing here. These new rules came down on October 18th of 2018. So you don't look back beyond that date. So we're really only going to have a 3-year look back when we reach October 18th of 2021. So they're not looking back that far at this time. Now, absent clear and convincing evidence showing otherwise, the VA is going to presume that any asset transfers made during this time period were made to establish pension entitlement. The changes establish, as I mentioned, a 36-month look back and a penalty period, but that period is not to exceed 5 years. So you are not going to be ineligible forever. And of course, as we'll get to in a moment, you'd have to transfer a lot of money to be ineligible for 5 years. Transfers are going to include any transfer to a person or to a trust. So if you create an asset protection trust and try to transfer assets to a trust, it's still the same problem with the look-back period. You're going to be not eligible if you make that transfer within those 3 years. They also include the purchase of annuities. These are financial instruments or investments that tend to reduce the net worth of the applicant. With these investments, there's really no other reason to buy them but for the purpose of trying to qualify for aid and attendance benefits. So you try to buy an annuity and reduce your assets, that's going to be considered a gift as well. So the interesting thing about the period of time that a veteran is ineligible for benefits is that the calculation is not based on the total assets transferred, but only those assets that exceeded that net worth figure. So remember I said that net worth figure is about $126,420 today. You have to be transferring monies that exceeded that figure in order to have a penalty assessed. If you only had $100,000 and you transferred, let's say, $10,000 to your child out of that $100,000, well, $100,000 is under the $126,420, so they're not going to assess a penalty. It's only the monies above that number. And keep in mind it changes every year. So if a veteran had $130,000 and they transferred $20,000, only the amount above the maximum resource allowance of the $126,420, in this case about $3,600, is going to be considered a penalized transfer. So the rules are really different from the Medicaid system. For those of you familiar with Medicaid, here the VA is only going to penalize if you transferred money in an attempt to get below the $126,420. And the calculation of the penalty is going to be determined by dividing the amount that was transferred by the maximum annual pension rate as of the date of the pension claim. So currently, on the prior slide, you may have seen that that figure is $2,230. That's the maximum amount you can get from the VA right now. So if the claimant made a $100,000 gift in excess of the CESRA within the 3 years prior to the claim for the pension, the penalty will be calculated by dividing the $100,000 by the 2230, resulting in a period of ineligibility of approximately 45 months. Now, the penalty period would start on the first day of the month following the last asset transfer. So the clock starts ticking the month after the transfer is made. So it's possible that you made these transfers a long time ago, maybe 2 years ago, and that's when the clock started running. So a relatively small transfer back then of $10,000, $20,000, $30,000 probably has run out by the time you're applying today. So that's another great benefit of their rules, is that unlike in Medicaid, where the clock doesn't start running on the time you make the gift unless you're otherwise eligible for assistance, in the VA rules, the month after you made the transfer, the last transfer, in fact, that's when the clock will start running. So once a penalty period decision notice is issued, the claimant does have 60 days following the decision to cure or partially cure a transfer, and then 90 days following the decision notice to notify the VA that they have in fact cured the transfer. So you've got some time to get the money back and undo the transfer if you want to avoid a penalty. So one of the most significant changes to the eligibility rules for aid and attendance is the limitation on exempting your acreage surrounding the residence. If you have a home with a fair amount of land, you may not be eligible for that aid and attendance benefit in the future. As it stands right now, the VA rule will be tough to overcome. You may not want to sell those acreage, the farmland that you have. It's valuable to you and your family. but you don't have a lot of other monies. So you're kind of in a predicament here. You can't get the VA benefits because of this acreage. You can't sell it. So what's one of the planning techniques you can utilize now if you're planning ahead? Well, you want to transfer ownership perhaps of the home and that acreage well ahead of the need for these benefits, so well outside of that 3-year look-back period. One of the tools that is available to you is this irrevocable asset protection trust. These are trusts intended to protect assets from your long-term care costs. They're legal arrangements to essentially have the trust own either money or real estate. Once you've transferred these assets to the trust and made it through the look-back period, the money or property in that trust cannot be counted as your available asset. Now you can use and enjoy what's in the trust from the standpoint of enjoying your home. You get to live there and use and enjoy it, but you don't own it anymore, and therefore after the 3 years or 5 years, if you're trying to plan for Medicaid, you don't have to tell the government what's in these trusts. It's outside of the look-back period. The asset will be protected from the cost of your care. You will have to name a trustee to manage the trust. And again, we were talking about this today. We always name one or more of your kids as the trustees rather than having you as your own trustee. The trust lasts only so long as you are alive. Once you die, the trust pays out to your children who are the beneficiaries of the trust, so it operates much like a will. Now, here are some facts about these trusts. Think of the trust as a person on paper, so rather than directly transferring your home and all that land to your kids, you can transfer it to the trust and keep it safe during your lifetime. Using these trusts protects the assets in the trust from what's going on in your kids' lives. Whether your kids get divorced, they have a disability, they predecease you, they have creditor problems, or you just have a falling out with them. Your child doesn't own what's in the trust until you die. It stays in the trust while you're alive. So if you transfer your home to the trust says you get to use and enjoy it for the rest of your lifetime. You still have to pay the taxes, maintain the property, as you do now, paying all those utilities, but you have that protection that the trust allows you to live in the home for the rest of your days. If you want to sell, you can do so. So your trustee will put the home up for sale, the money comes into the trust, and then you buy a smaller home or relocate to perhaps a different environment. When you die, the home doesn't end up in your probate estate, so the government cannot put a lien on the home. And in both the Medicaid program and in the aid and attendance program, they like to go after assets that are owned by the Medicaid recipient or the aid and attendance recipient and recover from the estate of the person who got the benefits. And with a trust, trusts are not part of your probate estate, therefore they avoid these liens. You can put money in the trusts, investments and so on. So if you have some other resources you'd like to protect, you can do so. It's more of just a changing of the name on the account wherever you have your money located. Instead of Mr. and Mrs. Jones, it becomes Mr. and Mrs. Jones Family Trust. But if you need the money that you put in there, you can get the money out. However, you need the cooperation of somebody else to do so. It's normally one of your kids that helps you get the monies out. Keep in mind, these are family trusts, so there's no bank involved managing your assets. So you don't put everything you own in these trusts. It's just those assets that you're intended to trying to protect or get out of your name, so it will be easier to qualify for those government benefits if something happens to you down the road. And keep in mind, it's an early planning technique with those look-back periods, 3 years for veterans benefits and 5 years for Medicaid. You've got to be planning ahead with those trusts. So what can you do now? Well, if you're concerned about getting aid and attendance benefits, now's the time to get a consultation, figure out if you're close to being eligible. And I should point out, every county has a VA representative. Normally either in the courthouse or in the county administration building, you'll have a VA rep with an office. You can always go in, take your discharge papers, disclose most of your assets, and the rep will give you an idea of how close you are to being eligible for VA and go over these same rules that I've discussed with you today. Plan ahead. My recommendation is that if you're well over-resourced and you're going to need to do some planning, now would be the time, if you're relatively healthy, to make some transfers of assets to get yourself eligible for these benefits, and particularly in light of the 2-acre limitation associated with the real estate. I'm worried about some applicants in our region here in who have larger pieces of real estate but not a lot of savings, they might be adversely affected by these new rules and may need to do some planning. All right. So if you have any questions about the new aid and attendance rules or maybe the Asset Protection Trust, don't hesitate to contact us. I can schedule a consultation and visit with one of our attorneys. And we also have some webinars on our website for other topics that may interest you. We had talked last week about filial supports, and we're going to be coming up talking about some ideas for professionals who might be interested in what are some of the estate planning concepts that they might need to look out for with the average client. So do check out our ECLA newsletter and our website for upcoming webinar ideas as well as workshops. Thank you very much for attending.